Imagine you are at home in a suburb of Munich and you decide to create a digital spreadsheet to keep track of your family's holiday gift list, including the full names, home addresses, and phone numbers of 30 relatives. If a random stranger were to hack that list, you would certainly be upset. But the European Union does not expect you to follow the complex GDPR compliance rules for your personal gift list. This falls under the personal or household activity exemption. The formal regulation states that the GDPR does not apply to the processing of personal data by a natural person in the course of a purely personal or household activity. In simple words, this means if you are doing something strictly for yourself, your family, or your friends, and it doesn't involve a professional, commercial, or public scope, you are off the hook. It is a common sense barrier that prevents the law from policing your private life. However, the moment you take that list, turn it into a business, and start selling gift recommendations to those same relatives, you cross the line from personal to professional. So now that we have mastered the core concept of the household exemption, you might be wondering where that line between personal and business actually gets drawn when technology is involved. Well, that brings us right into our next step, which is the professional versus personal overlap. Think about a freelance photographer based in Paris who manages a small database of client wedding photos and contact details for his business. Even though he is a natural person acting alone, he cannot claim the household exemption because he is engaged in a commercial activity that affects others. You have probably seen this at the office where someone thinks because they are a small shop or a one-person company, the rules don't apply to them. But that is a dangerous misunderstanding. The GDPR doesn't care about the size of your team. It cares about the nature of your activity. If you are collecting data for business, for a club, for a blog, or for any organization, you are within the scope. We see this often with people running small e-commerce stores from their kitchen tables. They are not household users anymore. They are data controllers. Understanding this distinction is the first step in avoiding massive fines. So now that we've mastered the difference between a truly personal hobby and a professional activity, you might be wondering what happens when governments themselves collect data for law enforcement. Well, that brings us right into our next step, which is the Law Enforcement Directive and its unique boundaries. A police department in Berlin needs to process sensitive data regarding a criminal investigation to ensure public safety. If the GDPR applied to every single piece of police work in the exact same way it applies to a marketing firm, it could grind essential security operations to a halt. This is why we have the Law Enforcement Directive, or the LED. It is a separate legal framework that governs data processing by competent authorities for prevention, investigation, detection, or prosecution of criminal offenses. Think of it as a specialized lane on the highway. While the GDPR is for the general public and business, the LED is for the state's security functions. It balances privacy rights with the absolute necessity of keeping society safe. You need to keep these two frameworks separate in your mind. The GDPR is for commercial and administrative life, while the LED is for the heavy lifting of state security and justice. So now that we've mastered the divide between commercial privacy and state security, you might be wondering how we handle data that is processed purely for national security or defense. Well, that brings us right into our next step, which is the national security exclusion. An intelligence agency in Brussels is monitoring a potential threat to national infrastructure. This activity falls completely outside the scope of the GDPR. This is what we call the national security exclusion. Activities concerning national security, such as intelligence operations, defense, and military actions, are generally left to the individual member states of the European Union, not the EU regulation itself. It is a matter of state sovereignty. You have to remember that while the GDPR is a powerful, harmonized law, it does not have the authority to reach into the highest levels of a nation's defense apparatus. When you are auditing a company, you will rarely encounter this. But as a professional, you need to know that this black box exists where the GDPR simply does not tread. It is a reminder that even the most comprehensive privacy law has its limits. So now that we have mastered the concept of national security exemptions, You might be wondering how we handle cases where the data is actually used for journalistic, artistic, or literary purposes. Well, that brings us right into our next step, which is the freedom of expression and information. A newspaper in Madrid publishes an investigative report revealing the financial corruption of a public official, including private transaction data, to prove its point. If the official sued the newspaper under the GDPR claiming their right to erasure or data minimization, the newspaper would argue the journalistic exception. The regulation dictates that member states must reconcile the right to protection of personal data with the right to freedom of expression and information. In simple words, this means the public's right to know is balanced against an individual's right to privacy. It prevents the GDPR from being used as a censorship tool. We see this frequently in cases of historical research or artistic projects where a person's name might be used in a book or a play. The law does not want to stop the truth from being told or art from being created. It is all about the balance between transparency for society and privacy for the individual. So now that we have mastered the balance between privacy and free speech, you might be wondering how to summarize these complex exceptions into a reliable audit strategy. Well, that brings us right into our next step, which is the final audit checklist for exemptions. To wrap this up, remember that claiming an exemption is a high-stakes decision. I once saw a startup in Lyon claim they were a personal project to avoid registering their data processing, only to be hit with a massive audit later because they were actually selling customer profiles. As a CIPP professional, your job is to treat the GDPR as the default setting. Never assume an exemption applies unless you can document exactly why. When you walk into an organization, your checklist should be: is it purely household? No. Is it purely law enforcement or national security? Probably not. Is it purely journalistic? Verify the evidence. If the answer to these is no, then the GDPR applies and you need to get to work. By being rigorous about these boundaries, you build a foundation of compliance that is bulletproof. You have now moved from the theory of who is covered to the practical reality of defending your organization's position. You are the guardian of these boundaries, and you are ready to apply this knowledge to any professional environment.